20, matter of Town of Irondequoit. Counsel?
Good morning, Your Honors. I am Megan Doherty of Carter, Seacrest, and Emery Attorneys here today on behalf of Appellant the Town of Irondequoit. With your permission, I would like to reserve 2 minutes for rebuttal.
Okay, and I'd like to remind counsel, given the state of where we are, between the mask and the microphone, please speak up and speak into the mic. Thank you.
Thank you, Your Honor.
You're welcome.
May it please the Court. Monroe County is legally obligated to guarantee and credit the Town of Irondequoit for all unpaid property maintenance and demolition charges. And in fact, it did so for many, many years until December of 2016.
Counsel, during that time, up here, sorry.
Thank you.
During that time they were paying this, up till 2016, I guess, were they also paying special assessments? Others, regular special assessments that everyone would agree qualify?
That is my understanding, yes. I don't believe there's anything in the record on that, and perhaps counsel for the county can confirm, but that is my understanding.
How long have they been paying this? I don't know where I got it from, where in the record or in the briefs I got it from, but I thought that this issue had been brought up in a case that goes back to the 1930s. Is that right?
You're exactly right, Your Honor. There is a case actually between the Town of Irondequoit and the County of Monroe.
Yeah, it's a miscellaneous case. It didn't go to the appellate division of the Court of Appeals, but the practice then seems to have been resolved in 35, and it's been the same since then. Is that correct?
That's exactly right, until 2017 with the issuance of the tax memo.
I see. Okay. Go ahead.
And the reason that Monroe County did this for so long is because the law compels them to do so.
Well, did they give a reason why they stopped? Or did they give you a legal argument why they stopped?
So when the county issued the tax memo, it did purport to give legal reasons, saying that they were unable to continue to legally guarantee and credit these particular charges. It was actually a list of charges that included ambulance services, electric services, building permits, and these particular property maintenance and demolition charges. And if you look at all of those, the property maintenance and demolition charges are very different from the rest of them.
Let me ask you this before you get on to the differentiation amongst those based on what you said. So was it your understanding once they issued this tax memo that they were simply saying they couldn't guarantee it, but that in the future they might be able to pay it, or it depended on the amount?
It was the Town of Irondequoit's understanding at that time, and it continues to be, that in fact they were refusing to guarantee and credit the property maintenance and demolition charges from that point forward. In fact, when we brought the Article 78 proceeding, we were looking for preliminary injunction relief because the county at that point intended to deduct some of the sales tax monies from what the town was owed.
No, I understand that's what they said they were going to do. Mine is a slightly different question. Is it your understanding that that's what they're going to do now, given what they perceive as the amount and the burden on them based on what they've written in their brief? And if that amount and the burden change, that they might return to giving credit?
There was no indication of that in the tax memo, Your Honor. In fact, they seemed to set up the tax memo to say that it was illegal for them to, in fact, to continue to credit and guarantee these particular charges.
Right. Thank you.
So for charges over here, for charges where you're able to put a lien on a piece of property, if you can't collect through the tax foreclosure, the county doesn't, guarantee it and send it to you, how would you go about collecting that?
From the town's perspective, we would have to wait for the county to initiate the tax foreclosure proceeding, and that would be really their only remedy.
It would be what, I'm sorry?
That would be the only way that the town could recoup the money, in which case the town faces a very difficult decision. Do they try to address these blighted properties and protect the health and welfare of the town residents, or do they risk not being able to recoup the expenses that they spend on these property maintenance and demolition
So
charges?
you have, just so I understand clearly, you have no direct way to foreclose on your own lien?
The town does not have the authority to do a foreclosure sale. That's correct. Only the county does, and that's a big difference between many of the cases and the agency opinions that deal with cities and villages. Because cities and villages actually have that power, that they can initiate the tax foreclosure sale. Towns do not have that. So they are, in essence, captive to the decisions of the county as to what they will be able to recoup if, in fact, the charges are not guaranteed and credited.
But under your reading, they have no say and no control over the amount, because you all decide what maintenance, regardless of the cost, to actually handle yourselves if the owner is not willing to do so. So they're sort of left with the bill with no input on how indeed to perhaps minimize the costs.
That's exactly right. In fact, the legislature set it up that way with the town law sections that are relevant here. The towns, because they are charged with protecting the health and welfare of the town residents,
So is your lien worthless then? Is that apropos of Judge Wilson's line of questions?
Not necessarily. I mean,
Okay.
I suppose there's a possibility that if there's property maintenance and demolition charges that are levied, and then the tax goes to, the property goes to a foreclosure sale, and there's enough surplus that once we get through priority to where the town taxes lie, that in fact the town could get reimbursement, but it's
So
certainly...
you do have a path.
It is
You do have a
but
path to collecting. It's just not the one you prefer.
well, and it's not one that we direct either, so...
It's not one that you,
that we have any say in when it takes place and how it takes place.
well, in the same way they don't have any say in the actual maintenance charges that you choose to pursue, right?
Not quite, Your Honor, because in fact, the legislature has directed that it is the towns that can impose these charges pursuant to the town law, and the amount of the charges and the propriety of the charges actually is something that the county cannot argue, and that was established in the
Let me ask
town
you
of
this, is there
Amherst
any
case.
type of, from your perspective, in the law, any type of limitation on the nature of the maintenance? I mean, they mentioned, right, mowing the lawn, which, is there some kind of limitation on the nature?
Absolutely there is, and it's through the legislative process, because all of this was done pursuant to the town code as well, that sets the minimum standards for the maintenance of these properties. So really, to the extent that the county has any concerns, it needs to be addressed through the legislative process, not only at the statewide and the county level, but also at the town level.
So what is the limitation? Mowing the lawn is or is not included?
There's certain circumstances under which mowing the lawn would be included. When it gets to be a dangerous situation, the weeds are too high, there's infestations that could be possible, it becomes a hazard to, people who may be in the area. Those are the circumstances under which some of the property...
Has there been an upsurge in problem properties in towns? And is this what prompted the dispute? Because it seems to have been a relatively stable system. I read about things like zombie homes. And is there a public policy basis that's resulted in an increased cost that would cause the county to pursue this alternative approach?
Your Honor, I wouldn't want to speculate as to what prompted the county to take this position, but I can say...
Well, what do you say about your town?
For our town, yes, we have seen an increase in this, and I don't think that we are alone in this. The Association of Towns
Well,
submitted...
you've seen an increase in what? Zombie properties?
Yes, that's exactly right. These are, and primarily uninhabited properties, ones
So
that...
have those properties then caused an increase in the cost that the town has to incur to maintain them?
On an aggregate basis, yes.
Because, if I understand it correctly, and that's because you don't want to demolish the properties, cleanly you want to preserve them to preserve the tax base of the town. So that's increased costs, and then those costs are passed on to the county, and they say, they have an argument to say that this is outside of what we agreed to.
That seems to be the case. And I think that we're seeing New York State, I think probably in the aftermath of the financial crisis from 2008, where there's a lot more lenders who own these homes that aren't inhabited. It's difficult to get the lenders to actually do this type of property maintenance. And in 2015, 2016, Governor Cuomo, in fact, really addressed this issue of zombie homes and made them a priority.
Counsel, I just have one quick point. I know your light's on, but as I understand it, and maybe I have this wrong, going back to, I think, Judge Wilson's question, the fact that they're not reimbursing you for these costs, does that affect the priority of disbursements from the tax collection? That is, the fact they reimburse or don't reimburse, if they collect $10,000 on a foreclosure, are you still at the front of the line for these charges, even though they're not payable by the county if there's a shortfall, or does that somehow reduce your priority in the payout scheme?
I don't.
So let's say they have $10,000 they get on a foreclosure, on a sale, and the property taxes for the town are $9,000, and you get that. There's $1,000 in county taxes, and then there's your other charges. Does it make a difference who gets the $1,000 if they're reimbursing you or not reimbursing you? Because they're still going to collect, right? You're still going to list those charges. They're still going to foreclose, and if there's enough money, you're going to get paid. So my question is this really just a prioritization issue? Is it really just a reimbursement issue and not a priority issue, right?
It is absolutely a reimbursement issue.
Right.
You're exactly right. And it's a question of who's best prepared to handle not only collecting these monies, should this go to a tax foreclosure sale, but also who's in a better position to do so. And clearly the county
But it doesn't
is.
affect your lien. You have a lien, you're going to make it part of this bill, and if there's money, you're going to get paid. It's just if there's no money, the county isn't obligated to pay.
That's exactly right.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honors. My name is Kenneth Gordon. I'm the attorney for the town of Brighton. I just want to pick up on a couple of themes that Ms. Doherty touched
Sir,
upon.
before you do that, would you just educate me a little bit more about what the process is of how you assess these charges? Take me up to the time when it goes to the county.
Sure. Under town law, the towns in New York State are authorized to enact local laws, and we've done that in the town of
I know the
Brighton.
legal background. I'm actually asking you about the practical steps that the town takes when it has one of these properties. What does it do? And
Yes, Judge, we send notice, we send written notice to the homeowner to try to get them to fix the problem. And these are always health and safety concerns. We don't take action on somebody whose lawn might be a couple inches too long on a particular day. We're looking for health and safety problems. We send a letter to the homeowner. We notify them. We then, if the problem isn't fixed within a reasonable period of time, we send a second notice to that homeowner. We then schedule a public hearing for that property. We then go through the process of making sure that that homeowner knows what's going to happen. And then the work is done. That work is either done by town staff or contracted out, depending upon what the work is and what availability town staff has. And the cost of that is then added to the tax bills. We notify our town clerk or our tax collector. And at the end of the year, when that tax collector is charged with reporting to the county, he or she reports it to the county as an unpaid tax, if that in fact is the case.
But the county isn't put on notice when you're sending these letters and conducting the public hearing.
Fair.
It's not
That's
till
true.
after it's all completed.
That is very true, yes. And I know that there was some concern, or at least I thought I heard some concern expressed about the fact that the county doesn't get to have a say about how much money is spent on these maintenance or repair charges. And while that's true, let's also not forget that the county is the one who has the ability to have a windfall here if the property goes through foreclosure and the county reacquires that property for far less than the actual appraised or
How
value of it.
often does that happen? Do you have any idea?
I don't know the statistics on how often it happens, but it certainly does happen. So, and the town certainly has no ability or right to participate in that windfall. All that the towns can hope for is that there will be a credit given back, as it has been done for many, many, many decades.
And these charges, do they go actually on the tax roll, or they do?
They do, yes. They're part of the tax roll that goes then into the county.
So-
The county
so-
is, yes, I'm sorry.
Yeah, no, I'm sorry. So now let's do a little of the statutory interpretation here. So what is your strongest argument for why these are taxes under 9361?
So,
These kinds of charges?
Right, Judge, these are delinquent taxes. I think there's two
Well,
very...
we first got to get to their taxes, so let's start with that. I understand you're arguing they're unpaid, but let's start with the taxes.
Right, I think that the argument that the appellate division dissent made is a very strong and important one. This is an overall statutory scheme. It is a mistake to look at one word and try to define one word. We need to try to discern what the overall legislative intent here was. And it's the legislative intent not of the county, not of the towns, but of the state of New York. The state legislature and the governor have made a priority to make sure that they have given to the towns the ability to charge these charges on the tax bills, to state that they should be collected as a tax. They have provided a mechanism for the county to foreclose on those tax
Point me
liens.
to, you say you got to look at sort of in context, not excise one word and sort of decide everything on this one word. So give me this context that you're pointing to.
Sure. So Town Law Section 64, which gives the towns the right to create these local laws, to impose these maintenance and
Yeah.
repair and demolition charges,
Yes.
and that those should be a lien upon the properties,
Okay.
and that they should be collected as taxes. No one other than the county has the right to foreclose on those tax liens. That's also a product of state law.
I'm sorry, where does it say collected as taxes?
Under Section 936,
Oh, I'm sorry, I thought we were talking about the
skipped-
town law,
right,
my apologies.
Right. It says that those charges and those taxes that are reported off the tax rolls at the end of the year as delinquent taxes need to be paid and collected as taxes by...
So you're saying because you put these charges on the tax roll, that then brings it within the ambit of 936-1?
Well, and also we have Section 11022, which defines delinquent taxes to include not just taxes and ad valorem taxes and special assessments, but also other charges imposed upon real property by or on behalf of a municipal corporation. That's exactly what these
Doesn't
are.
that definition only apply for that article, and 936-1 is in a different article?
They are in different articles, but the tax scheme that was created here was created by the New York State Legislature. And part of that scheme also now, and I can't remember which
Well,
judge raised this.
1102 actually refers directly to 936, doesn't it?
It does refer specifically to the collection of taxes, delinquent taxes under Section 936.
And is there a section in 930, in Article
Article
9 that also refers to Article 11? I thought there might have been.
I am not aware of what that is. I do not think that there is a specific definitional section in Article 9 that talks about what a delinquent tax is.
No, I agree with that. Yeah, this would be an unrelated section. I'm just sort
But
of
you're right.
asking you about the cross-referencing within the two articles.
The cross-reference in 1102 begins at the point of that it's a tax. So we're still back. It doesn't answer the question whether or not this is a tax. We're still back to that. So tell me what your strongest argument is on that. You're telling me about the statutory scheme.
Right.
So work with me on that.
And my position, Your Honor, is that the statutory scheme is where the court should focus. The fallacy in the majority's decision below was that these charges only benefit, look at it, look at that decision, only benefit one single property. And we know from the increased zombie homes and the blight on those communities, and the emphasis placed by the governor and the legislature on fixing that problem, that these blight problems affect entire communities and neighborhoods. And that's why we need to have a system that allows towns to impose these charges, collect these charges, get reimbursed through
But that
through
argument
the
in many
county.
ways applies to any service that's done on any property, right? That as long as any property within a community is maintained, that the benefit inures overall to the entire community. That is true. I would never disagree with you about that. But the question is whether or not, given the kinds of definitional, the definitions in the real property tax law, whether or not one can say that this type of maintenance is a tax for purposes of 936(1). And this language that says unpaid delinquent taxes, doesn't that refer back, because it says such unpaid delinquent taxes, to the earlier language in the paragraph? I don't know that that answers addresses the issue as to whether or not these are taxes in the first instance.
Right. I understand the concern, but I also see that in 1102, where we're talking about the collection of delinquent taxes, it refers to not just the word tax, right? It also talks about other charges imposed by municipal corporations and assessed against those properties and reported to the county pursuant to 936 as a delinquent tax. So it provides an overall scheme to focus on just whether this particular maintenance charge or this particular demolition charge is or is not, technically speaking, under Section 102 of the real property tax law, a quote-unquote tax. That's a mistake. You need to look at the overall scheme. The overall legislative intent here is what should rule the day and should result in this court reversing the Fourth Department and issuing a mandamus that requires the county to pay and reimburse the towns.
Thank you, counsel.
Thank you.
Counsel?
Good morning, Your Honors. I'm Michelle Romance Crane. I'm here on behalf of the respondents, the County of Monroe. It is our position that, in fact, the Fourth Department decision should be affirmed. All of the justices at the Fourth Department determined that these charges are not taxes.
Why isn't he correct, though, about this interpretation of 1102? Why isn't that dispositive here?
I think that that this particular statute, we aren't going to commingle those statutes. We're going to rely on the definition of tax as used by the Fourth Department, the common sense statutory construction argument that these charges are not taxes.
But
So
the
then-
cross-references, I'm
I
sorry.
apologize.
It cross-references, 1102 cross-references 936. I mean, I think your argument would be good, except for that fact, because Article 11 says, is used herein, and it's the procedural part of it. But it's a hard way to distinguish it because it refers to the delinquent taxes listed in 936, and it includes all these different things, assuming those things are included in the delinquent tax list from 936.
I think there's a distinction, though, between what's defined as a tax and we have the tax, the special ad valorem levies, and the special assessments. They are distinct and different, and I think that is important, and we can't just look at this in a vacuum and
But
say,
then what is the purpose of the reference in 1102 to 936? What meaning
that the
does it have?
taxes would be guaranteed.
Well, but
That
it
would be
said-
my interpretation of
But
it.
it says what delinquent tax means, and it includes taxes, but it also includes other charges. And then it refers back to 936.
I would just agree with the Fourth Department's determination that, in fact, it is not a tax.
Why wouldn't
And a
we-
delinquent tax is something that's being collected. We talked, in the dissent, they determined that this was a special assessment, and then they said that it can be collected in the same manner as a tax, but that doesn't make it a tax.
So the RPTL Section 102 has a definition of tax.
Oh, sorry.
Sorry, the RPTL Section 102, sub 20, defines tax. Why wouldn't we use that definition?
We would rely on what the Fourth Department did in determining the statutory construction of 936 and what the meaning of tax means in that statute.
I guess I'm asking why we would disregard the legislature's definition of tax if we have one.
I don't think that that's the sole definition of tax.
Is
Or
it,
I think what you're talking about is delinquent tax, not tax.
no, definition of tax. It says tax or taxation means a charge imposed upon real property by or behalf of a county, city, town, village, or a school district for municipal or school district purposes, but does not include a special ad valorem levy or a special assessment.
It does not include a special assessment, and all the judges at the Fourth Department determined this is a special assessment.
No, the
Why do we-
majority didn't decide that at all. They punted that
sorry.
question, didn't they? Didn't the majority say we're not deciding whether this is
They
special
decided it
assessment?
was not a tax. They did not decide, and they
But
said it was not a
Even if that were
tax.
true, in our review, shouldn't we just simply look at the plain language here?
Yes, Your
And-
Honor.
And doesn't that charge imposed upon real property phrase reinforce Judge Wilson's point?
Yes, we should just, we
It
should,
seems straightforward to me that this is a charge imposed upon real property.
it is. It's a
Right.
charge imposed upon real property. It's a special assessment, not a tax.
So, counsel, do you know, does the county, assume a straightforward special assessment that meets the definition, does the county guarantee, let's call it, that payment to the town?
Well, the county did in the past, as the court and council have advised.
So-
But I think Fresh Eyes looked at it
No,
because
but
of what
right now,
happened.
a special assessment that was levied this year, or past tax year, and you collect, and you don't collect enough on the property in a foreclosure, would you pay the town that amount? If it's a special assessment, we all agree it's a special assessment, a different,
Today?
Yeah.
Or
not this, whatever we call this,
The-
but a
the-
real special assessment.
they would, it's not a tax.
So you
no.
would not reimburse now for that?
No.
Not reimburse, you would not pay
We
out?
would not guarantee it because it's not a tax. As defined by law, a special assessment is not a tax.
So that change in your policy affects not only these types of zombie home charges, but any special assessment?
Yes.
Okay, thank you.
So your argument about, you're focusing on the word tax, and it seems to me that if there was no separate definition in the RPAPL of delinquent tax, then one might read it as, okay, talking about tax in the first part of the sentence, and delinquent tax refers back to tax. But because there is a separate definition of delinquent tax, which refers directly to 936, why does this have to be a tax as defined in Section 102? It's a delinquent tax as defined in Section 1102. Two different things, two different animals. Why shouldn't we read it that way?
You could.
And if we did read it that way, then is the county
I think the county's
obligated
position
to
is,
guarantee?
pardon me, I think the county's position remains the same, that you shouldn't do that, that this is not a tax as defined by law using statutory construction rules. It's clearly not a tax.
But if we
And
do read
and
it-
all the judges at the Fourth Department determine that.
But if we read it as a delinquent tax, something defined differently from tax, then is the county obligated to continue to guarantee that?
I would say no, that we should rely on the language, the definition of the word tax.
How are we to take the state agencies who have reviewed this? I think the State Board of Assessment Review and the State Attorney General have both issued opinions that seem to favor the towns in this instance.
And I think in the brief that is addressed that,
Well, tell me
Yeah.
what you say here.
pardon me?
Tell me what you say here today.
What I say here is that they do not have specialized knowledge regarding this issue, and therefore their opinions should not be given deference.
Well, I usually like their opinions, and so I go along with them. When I don't, I take your position, but it's not always the case, you know.
Counsel, let me direct your attention to the definition of special assessment in 102.15. What's the meaning of the phrase, special, let me see what it says exactly, a special district, hold on one second, special improvement or service in that statute? What does that mean?
Bear with me 1 minute.
What is a special improvement or service?
I think those, the special assessments relate to, if I'm correct, special services for just those particular properties.
Well, no, isn't that an area that's specifically zoned? Like a business district will be a special improvement district, and there will be fees that are added on extra to encourage development. So for instance, they will charge more money because they'll have special garbage pickups, say maybe twice a week. Or they will have an extra cleaning crew that comes up and down and sweeps the public areas. And in that special improvement district, they have an additional charge that's added there for the service. Those are a little bit different than what we're dealing with here, aren't they?
Yeah, and in order to have a special assessment, you don't have to have a specifically designated.
Let me stop you a second. A special assessment is different from a special improvement district.
Right.
With its assessment costs.
That's what I was just, I was just going to say that, yes. So I think one of the
So, I'm sorry,
factors.
just to be clear. So, and I get the part about the special improvement district. So your position is a special assessment need not be connected to any district. This is just
Yes,
a service, and then you charge for the service.
yes.
Okay.
Yes.
Yeah,
I would also just like to add, I think one of the reasons that this issue came to a head for Monroe County is that, in fact, the charges that they were receiving from the town of Irondequoit were becoming extremely large, and the county had no control over them. And what was happening is that all of the citizens, the tax-paying citizens of Monroe County, were now were in the position of having to guarantee these charges from towns such as the town of Irondequoit, who were charging $600 to mow a lawn and were deciding when they were going to demolish properties. But
their claim is, well, that is what the legislature intended, that you didn't have that kind of control. So then isn't the response to your concern, if they're correct, is that I'm over here, is that
Sorry.
no, it's all right, it's totally fine, that your recourse is to go to the legislature and say, you've got to rein this in. We can't keep bearing these credits.
I think their recourse for this is to go to the legislature. This is trying to create policy where it doesn't exist. There's a concern about zombie properties. The legislature could legislate it, and they could fix this inconsistency. Right now, what you have is that...
You mean by giving them the power?
They can go and create a new policy regarding guaranteeing these special assessment fees associated with the zombie properties. Right now, the county takes the position...
We're giving them the foreclosure power?
I'm sorry?
We're giving them the foreclosure power?
No, they don't need foreclosure power, by the way, to collect this money. And by the way, the county doesn't get this money. These properties, the county is basically, the taxpayers are guaranteeing these taxes and these unpaid fees, and they're never getting a windfall.
How else would they collect?
I don't think they collect very often.
No, how else would the towns, how would?
They have a lien on the property, so when the property is...
Okay, so what do you do with the lien? Oh, so when it's sold?
Yes, yes.
Okay, so that could be years down the road, right?
It could be, but the county taxpayers are now guaranteeing these fees for individual towns, when in fact, what should happen is that the cost should be shared. The county taxpayers are guaranteeing the taxes, and the towns would have to incur the cost of the special assessments.
So just to understand the earlier point, and it was the line of questioning you heard before about why break with the prior practice, what you're saying is that the numbers are now burdensome.
That's
and
one
that's why
factor.
you've broken with the prior practice.
Not the only factor, though. I think 80 years later, attorneys in the law department took a look at it because the cost was becoming exorbitant.
That's what I'm saying. The motivation, though, was this bearing of this cost. Okay.
Yes, the cost became so high, and the county has fiscal concerns, as do the towns, as does the state.
So what do the county attorneys say about Section 9 of the Monroe County Code that purports to guarantee other town expenses or charges?
I believe that is also addressed in the brief, and, you know, we are basically, I don't think that changes the argument here. The county is not guaranteeing payment of these fees.
to be clear here, you're saying you're not guaranteeing it, which doesn't mean that you might not under certain circumstances. Because that was your practice
well-
before, when it didn't seem to be so burdensome.
Of course, that's possible. That could happen. Yes, anything's possible. So I would just ask the court to affirm the Fourth Department's decision here. I would note once again that each of the justices there determined this was not a tax, and therefore it is not guaranteed pursuant to RPTL Section 936. Thank you.
Counsel. Counsel?
Thank you, Your Honors. Just briefly, the county suggests that it's incumbent upon the towns to approach the legislature and ask that they change the law to somehow require the county to guarantee these charges. But that's not necessary because the law, in fact, already requires
All
it.
right, so speaking of the law, I just want to understand, and I heard from the attorney for Brighton, but getting back to the point of the actual statutory interpretation, what do you think is the neatest way to get to the result that you want? Viewing this as a special assessment, viewing this as a delinquent tax, by saying the definition of tax includes this, as I think is one possible reading of Judge Wilson's question. What do you think is the neatest way to get to the result?
It is the town's position that these charges are taxes. And there's three different items that I would want to mention on that. First is the town law, and that says that these particular charges, if these expenses should be treated like charges and a lien against the property and treated like taxes.
But then it seems to me that then blurs the distinctions between all the different categories. The tax, the special valorum levies, the special assessments, the other charges. So what is the point? Part of my question is, what is the point then of distinguishing? And the other part is, if we agree with you that this is a tax, and certainly it has some attributes of that, how is that affecting a lot of other things in terms of real property taxation, or does it?
Well, we would say that the town law and these particular charges originate from these sections of town law 64 and 130, says that these need to be treated like taxes. So that's the legislature's intent. They don't, the legislature does
For
not.
collection purposes, right?
Pardon?
For collection purposes or for all purposes?
Well, they're supposed to be billed at the same time and in the same manner as taxes. Now, the legislature did not say that they should be billed in the same time in the same manner as special assessments, nor did the legislature say that they should be billed at the same time and in the same manner as special ad valorem levies. So there we have some intent to show that these should be taxes. Furthermore, as Judge Wilson pointed out, there is the definition of tax within the real property tax law. It says that a tax is a charge on the property, just mirroring that language from the town law, and that it's for municipal purposes, which clearly these charges for property maintenance and demolition are municipal charges. But we also have the Monroe County
Yeah,
Tax
but
Act.
haven't we said that municipal purposes goes to taxes that go to support the government, not looking at any individualized specific benefit that inures to a piece of property or taxpayer?
Well, actually, these property maintenance and demolition charges are broader than a particular property. I think I began to differentiate earlier some of the services that are not considered to benefit the public generally, and those would be ambulance services for actually transporting an individual from a property to a hospital, electric services as well, which clearly only benefit that one property, as well as building permits, which of course also only benefit that one property. But we also have the Monroe County Tax Act, and in there, the towns are directed to put these charges, and in fact, any expense taken for the town welfare, on the tax warrant and the tax roll. And it is from those two documents that any unpaid amounts are determined and the guarantee is actually effectuated. I see that my time is up.
Thank you, counsel.
Thank you.
Thank you very much.